This is a judgment of the court consisting of myself and my colleagues, the Honorable Justice Chomba, Acting Justice of Appeal, and Justice Mohoro, Acting Justice of writing the judgment of the court. My two colleagues concurred in it. For the reasons stated in the judgment, and those reasons can be found in full in which I would like to read out. A, the appeal is upheld. B, the portion of the order of the court at co-probable cause is set aside. And D, no order as to costs is made in the matter. I accordingly hand down the judgment. Kambide, Acting Justice of Appeal. We heard the appeal and our sister, Justice Nkambinde, prepared the draft for consideration, and myself and Justice Mohoro concurred in it. The reasons are fully set out in the judgment, and for those reasons, we made the following order, and I quote: A, the appeal is upheld in part. B, the portions of the order of the court are core, upholding the respondent's alternative claim with costs based on malicious continuation of the prosecution without reasonable and probable cause are set aside and substituted with the following order, quote within a quotation: the plaintiff's alternative claim based on malicious continuation of prosecution without a reasonable and probable cause is dismissed. C, the person claim is referred back to the High Court for determination in accordance with case management rules before any judge in the event that the judge who presided over the matter in the High Court is no longer available. And D, there is no order as to costs. I now hand down the judgment. Thank you. Thank you so much. This is a judgment of the court consisting of myself, Mr. Justice Mainga, Mr. Justice Smarts, Mr. Justice Hoff, all the justices of appeal, and Lady Justice Nkambide, acting justice of appeal. What I'm going to present is a judgment of the court. It's a unanimous judgment. Because of the importance of the matter, I propose to read out the judgment in full. It consists of some 48 pages, so please, it amends the principles of democracy and the rule of law as fundamental values that bind us and form our identity as a nation. The Constitution identifies Namibia as a sovereign, equality, freedom, democracy, social justice, and the rule of law as some of the major facets upon which our nation is founded. The Constitution also lays down frameworks and mechanisms through which these values and principles can be realized and enforced. The drafters of our Constitution are most effectively maintained and protected in a democratic society. The founding fathers and mothers gave effect to the notion of popular sovereignty through Article 17 of the Constitution, which entails the rights of citizens to participate in peaceful political activity intended to influence the composition and policies of government. It further safeguards the right of every adult citizen to vote and be elected to public office subject to the Constitution and the law. Elections are not perfect instruments for upholding the promise of democracy. Like any other public undertaking, they are susceptible to human error, voter fatigue, and the risk of being unrepresentative. However, they are a necessary premise for the legitimacy of government, facilitating the public's delegation of its inherent power to their representatives. The public's right to vote creates the executive's privilege to govern. It is therefore crucial that the voice of the electorate does and should find expression, meaning and content in the electoral process to ensure that elections are free, fair, accountable, and transparent. The Commission of Namibia, a body constitutionally charged with judicial intervention in the results of an election, but of the organized body politic. Parliament has both entrusted and obligated this in the public process of transparent elections, recognizing, as other jurisdictions have, that the elections are equally political and legal. The public is not deprived of other constitutional rights through elections, including the right of access to justice and the courts. Democratic institutions, the evolution of our present understanding of fundamental rights and freedoms is deeply for a democratic society where the government operates under a sovereign constitution and a free and independent judiciary. Similarly, this court has astutely recognized that the principle of democracy is deepened and augmented by the other two equally important principles proclaimed in the same constitutional breath, namely the rule of law and justice for all. Therefore, the supervisory power of the court does not detract from the popular sovereignty. On the contrary, it is indispensable to ensuring respect and categorical adherence to the letter and spirit. In this direct of the action of a member of the executive who selectively promulgated certain provisions of Section 97 of the Electoral Act, number 5 of 2014, which I shall refer to after as the Act, and sought declaratory order and consequential relief that includes the setting aside of the 29th president into the application. The applicants impugn the action of the first respondent, the Minister of Urban and Rural Development, responsible for regional and local government, as the minister henceforth, for his selective promulgation of the Act, more specifically in selective promulgation or promulgating parts of Section 97 of the Act, which was adopted by the legislature and signed by the President. That's in subsection 3 and 4 of Section 97. These two subsections were excluded by the Minister when the Act was brought into operation. They require a verifiable paper trail when use is made of electronic voting machines, separation of powers, and certain democratic principles described under Articles 44, which pertains to legislative power, Article regarding the assent to bills, Article 94B, concerning the Electoral Commission. And they also challenge the said action as allegedly having been properly exercised in terms of Section 209 of the Act. Section 209 empowers the Minister to determine the date on which the Act will come into operation and by notice in the Gazette. The applicants say that the action by the Minister was of irregularities relating to the use of EVMs during the election and also concerning the custody referred to as the respondents in this judgment, except where individually mentioned. The other presidential candidates and parties who participated in the election are also cited as respondents, but those have not opposed the proceedings. The respondents raised a number of preliminary objections to the application and also opposed it on its merits, including the irregularities contended for, and also opposed the relief sought. The 5 applicants were all candidates in the presidential election held on the 29th or 27th of November 2019. They seek to invoke this court jurisdiction under Section 172 of the Act, which empowers this court as a court of first instance to hear challenges to the election of the president. This section is quoted in full below in dealing with the respondents' attack upon this court's jurisdiction to hear and determine certain offences by the applicants and the competence of that relief. The facts relevant to the applicant's challenge concerning the selective implementation of Section 97 are largely common cause. The Act was passed in 2014, and the President assented to it on the 19th of September 2014. Shortly afterwards, and specifically on the 17th of October 2014, the Minister included subsections provide for a verifiable paper trail when voting machines are used, and further that the result of a paper trail would prevail in the event of disparity with the outcome of EVMs. Shortly before the 2014 national elections, a constitutional challenge was launched on an urgent basis in the High Court to impugn the Namibian Constitution Third Amendment Act of 2014, also to impugn Section 2092 of the Act and Government Notice number 208 of 2014. The 4 applicants in that case, including Mr. Maleski, sought orders A, setting aside the Third Amendment as unconstitutional for want of compliance with Articles 5, 17, 21, and 25 of the Constitution. B, declaring Section 209 unconstitutional with retrospective effect And C, declaring Government Notice 208 unconstitutional as it sought 3 and 4 of the Act inoperative. D, directing a proper running of the presidential election, in fact, presidential and National Assembly elections before E, in the elections of 2014, where voters used EVMs to be declared null and void. F, directing the ECN to run a transparent and credible election. And G, directing those concerned to stop using EVMs without a verifiable paper trail for every vote. That application was dismissed. The 2014 elections then proceeded with the use of, except that the EVMs used in the 2019 presidential election did not produce a paper trail. The importance of a paper trail to the credibility and transparency of elections is accepted by the ECN as, quote, the right thing to do, as conveyed to the Minister on the 26th of February 2019. But the ECN changed tack and simultaneously advised the Minister in that submission that A, its current supplier of EVMs could not achieve a verifiable paper trail in time for 2019 elections. B, this was not a legal requirement because Section 97, 3 and 4 had not been brought into operation. And C, that the High Court of EVMs without a verifiable paper trail. The ECN reported to the Minister that it was not in a position to implement what it termed a voter verifiable paper audit trail, or VVPAT. This declared in December 2015 that elections from 2017 onwards would have checks and balances enacted by Parliament, and that stakeholders would be informed when this would be implemented. The ECN's chairperson's denial of a statement attributed to her. The report was at no stage until her affidavit in this proceeding, more than 3.5 years later, ever qualified or retracted. On a matter of such public importance pertaining to a material aspect of voting, one would have expected the retraction or correction to have been made in the event of an inaccurate or incorrect report, given the ECN's unconstitutional mandate of independence and transparency. The ECN chairperson significantly failed to disclose what was instead stated, consistent with her subsequent statement to the Minister as to a paper trail being, quote, the right thing to do. This bare denial, in the context of this litigation, is not sufficient to raise a real or genuine dispute of fact on the issue, and it's, in our view, untenable. This court is justified to reject it on the papers alone. This is but one unsatisfactory aspect of the ECN's conduct concerning the lead up to the election and its opposition to this application. The public impressions thus created by the ECN was that the use of EVMs after 2017 would in all likelihood be accompanied by checks and balances in the form of a paper trail, as had been mandated by Parliament in subsections 3 and 4 of Section 97. The reversal of this position, communicated to the Minister on the 26th February, as already seen, was not, despite the ECN's constitutional obligation of independence, impartiality, and transparency, disclosed to stakeholders, indeed the public, as should have occurred. It is not disputed that the first application, or rather the first applicant, only established this reversal in the last week of October 2019. The election subsequently proceeded, and the sixth respondent, the incident, was declared, he's actually the fifth respondent, was declared the winner with the end of the vote. Applicant, an independent candidate, was second placed. He secured 29% of the vote. The applicants then brought this application within the prescribed time period. They seek to vindicate the election without a paper trail in the face of the requirements in subsections 3 and 4 of Section 97, passed by Parliament, meant that the election was invalid. After seeking a referral of the application to case management in Prayer 1, the following further relief was sought in the applicant's notice of motion, and I quote: 2, declaring that the determining by the first respondent that the provisions of Section 97 of the Act was to be brought into force, with the exception of Section 97, 3 and 4, on 17th October 2014 by Government Notice 208/2014 in Government Gazette 5593, was inconsistent with Article 1 of the Namibian Constitution, with the separation of powers under the Constitution, with Article 17 of the Constitution, with Article 28 of the Constitution, with Article 44 of the Constitution, with Article 56 of the Constitution, and with Section 209 of the Act, and accordingly is contrary to law, unconstitutional, and invalid. 3, setting aside the aforesaid determination by the Minister, aside the adoption by the Electoral Commission of Namibia of voting by way of voting machines in the 2019 presidential election. 5, setting aside the 2019 presidential election and the formal declaration on the 30th of November 2019 of its results. And finally, directing the conducting of a fresh presidential election compliant with the Constitution and the Act without undue delay. I may add that the costs were also sought against those respondents opposing the application. In opposition to the application, the respondents raised preliminary points. They challenge the merits of the relief sought and argue that the remedy sought in Prayer 5 and 6 above is inappropriate, even if the Prayer 2 is granted. The first respondent's preliminary point relates to the jurisdiction of this court. It is contended that the relief sought in Prayers 2, 3, and 4 does not fall within the purview of Section 174, and that this court does not have jurisdiction to determine those issues. The respondents contend further that this court is not competent under Section a reasonable time after that determination. It is argued that the failure to do so is fatal to this application. A further point is taken that the lawfulness of conducting elections with EVMs without a paper trail had already been determined by the High Court in 2014 in Maleski, which decided that conducting elections using EVMs without a verifiable paper trail was lawful. That judgment, so the argument continued, is binding, and if set aside by this court, then the result should apply prospectively and not retrospectively. The respondents also dispute the merits of the application and deny the irregularities contended for. The respondent late condonation for this was sought, it was not opposed, and it was granted at the outset of the oral proceedings. The parties had earlier participated in judicial case management in an appropriate spirit of cooperation, which has facilitated the ventilation of the issues in this application without delay. In terms of Section 209(1), the Act would come into operation on a date determined by the Minister by Government Notice in the Gazette. Section 209 provides, and I quote, "This Act is called the Electoral Act 2014 and comes into operation on a date determined by the Minister responsible for regional and local governments by notice in the Gazette." 2. Different dates may be determined under subsection 1 in respect of different provisions of this Act. Close quotation. On the 17th of October 2014, the then Minister determined that the Act came into operation on the date with the exception of sections 97, 3, and 4. This was done by notice in the Gazette, as already stated. Like its predecessor, the Act establishes and provides for the constitution of the ECN and determines procedures and mechanisms to facilitate the democratic representation in the institutions of state established by the Constitution. The Act does so by providing the statutory framework for conducting regular elections for those democratic institutions of state in a free, and I quote here, fair, transparent, and accountable manner. By regulating elections for the institution of state, the purpose of the Act is to give effect to the principle of democracy entrenched in Article 1 of the Constitution, as articulated in this court in the second case of Rally of Democracy and Progress, which we will refer to as RDP2 for convenience, in the following way, and I quote, "The essence of the democratic process by which the sovereignty and power of the Namibian people as a body politic are democratically converted into representative powers of state, exercisable by its institutions under the Constitution, was captured in an earlier discussion of the subject by this court," and a quote within a quotation. "The right accorded to people on the basis of equal universal adult suffrage to freely assert their political will in elections, regularly held and fairly conducted, is a fundamental and immutable premise for the legitimacy of government in any representative democracy. It is by secret ballot in elections, otherwise transparently and accountably conducted, that the socio-political will of individuals, and ultimately that of all enfranchised citizens as a political collective, is transformed into representative government, a government of the people, by the people, for the people. It is through the electoral process that policies of governance are shaped and endorsed or rejected, that political representation in constitutional structures of governance is reaffirmed or rearranged, and that the will of the people is demonstratively expressed, credibly and credibly ascertained." Close the quotation. The Act also provides for the conducting of elections in Part 5. Section 93(7), entitled Voting Machines in Elections, contained in Part 5 and provides as follows. 1. Before the commencement of the poll on a polling day at any polling station, the presiding officer must A. satisfy himself or herself that all voting machines to be used at the polling station are cleared of any votes. B. Permit the inspection of the voting machines by the persons entitled in terms of Section 94(1) to attend at the polling station and who are also present. And C. Immediately thereafter, close and seal all the voting machines in the prescribed manner. 2. Despite anything to the contrary contained in this Act or any other law, the Commission may adopt voting by way of voting machines in the manner as may be prescribed, including A. the manner of registering and recording votes by way of voting machines, B. the procedure relating to voting to be followed at polling stations where voting machines are used, C. the procedure as to counting of votes recorded by way of voting machines, and D. the safe custody of voting machines in respect of any constituency, region, or local authority area, as the Commission, having regard to the circumstances of each case, may specify by notice in the Gazette. 3. The use of voting machines referred to in subsection 2 is subject to the simultaneous utilization of a verifiable paper trail for every vote cast by a voter, and any vote cast is verified by a count of the paper trail. 4. In the event that the results of the voting machines and the results of the paper trail do not accord, the paper trail results are accepted as the election outcome for the polling station or voting thread concerned. The quotation now closes. Also of relevance to these proceedings is Section 172, governing the presidential election challenges, and it provides, 1. In an election of the president, any challenge relating to the return or outcome of the election, including any request to review electoral materials in respect of the election for the purposes of bringing a challenge. The challenge or request is directed to and adjudicated by the Supreme Court of Namibia as a court of first instance and final recourse as contemplated in Article 79(2) of the Namibian Constitution, read with Section 15 of the Supreme Court Act, Act number 15 of 1990. 2. Any proceedings referred to in subsection 1 is heard on an urgent basis, and the Supreme Court must give a written or oral decision and reasons for the decision at the conclusion of the hearing, or as soon as possible after conclusion of the hearing, having due regard to the complexity of the matter, but not later than 14 days from the conclusion of the hearing. 3. Subject to subsection 4, The Chief Justice must make rules as contemplated in Section 73 of the Supreme Court Act, regulating challenges referred to in subsection 1. 4. Until such time as rules referred to in subsection 3 have been made, the rules of court made under Section 73 of the Supreme Court Act apply with the necessary changes in respect of challenges referred to in subsection 1. End of the quotation. Now I move to the discussion on the contention regarding the question whether this court has jurisdiction to entertain the matter. The respondents take the point that the declaratory relief concerning the review of the impugned determination by the minister under Section 209 fall outside the ambit of Section 172, and that as a consequence, this court lacks jurisdiction to determine the issues raised by prayers 2 and 3 of the notice of motion, as well as prayer 4, which concerns a review of the ECN's decision to use EVMs without a paper trail. Mr. Mokari, who appeared for the respondents, argued that Section 172 should be given its literal grammatical meaning, and that the declaratory order and the review relief sought against the minister in prayers 2 and 3 respectively do not constitute a presidential challenge contemplated by Section 172. The declarator seeks an order of constitutional invalidity of the minister's determination, and the review relief would be consequential upon it. Relief of this nature, the respondent submitted, falls outside the scope of Section 172. It was argued that the relief sought in prayers 2 and 3 falls to be dismissed with cause on this basis alone. Mr. Gauntlet, who appeared for the applicants, argued that the use of the term any in Section 172 with reference to a challenge to the return or outcome of a presidential election connotes a spatial expansive jurisdiction. Applicants' counsel also referred to the broad and liberal approach of the Supreme Court of Kenya in interpreting the election legislation of that country, in constructing or construing its jurisdiction in the context of that legislation. Counsel also pointed out that a fundamental constitutional issue underlies the application as to whether the doctrine of separation of powers was breached by the selective implementation of the Act by the minister to exclude the checks and balances included by the legislature for voting by EVMs. Counsel contended that this was unconstitutional and rendered the outcome of the presidential election invalid, and thus brought that relief within the wider ambit of Section 172. Relying upon the tried principle that parties are required to establish jurisdiction in their pleadings, the respondents contended that paragraph 6 of the applicant's founding affidavit, which sought to establish jurisdiction, failed to do so. That paragraph reads, "At the heart of this application lies an important constitutional issue. This is whether the Constitution permits the selective promulgation at the choice of the executive of parts of Section 97 of the Act as adopted by the legislature. This is not, it will be shown, what Section 209(2) of the Act authorizes when it provides for provisions to be introduced at different times. The effect has been to introduce electronic voting machines without any check and balance at all of a hard copy record or a paper trail in respect of each vote cast as Parliament has specifically required." Close quotation. The respondents proceeded to characterize the relief sought in prayers 2 and 3 concerning the minister's determination as the applicant's primary or main relief. They argue that the declaratory and the review relief embodied in these prayers do not relate to the return of or outcome of the presidential election and should have been sought in the High Court within a reasonable time of the determination by the minister in 2014. This court's jurisdiction is pleaded by the applicants under the rubric nature and purpose of this application. Under this heading, then follows 4 explanatory paragraphs, including paragraph 6 that I have just quoted above. Properly read together and not in isolation as the respondent sought to do, These paragraphs demonstrate that the application is directed at the outcome of the presidential election. Paragraph 6, relied upon by the respondents, merely seeks to explain where the invalidity of the outcome lies and has its origin. The paragraph which follows paragraph 6 contends that the impugned presidential election has been vitiated by the breach of the constitutional principle of separation of powers, and paragraph 8 asserts an effective remedy flowing from the declaratory and review relief which relate to the outcome of the election. The relief sought by the applicants is composite and interrelated, and the challenge to the outcome is conjoined to the declaratory and review sought in prayers 2 and 3. The composite relief sought thus clearly relates to the outcome of the presidential election. The challenge to jurisdiction would appear to rest upon the respondents' own mischaracterization of the applicant's relief in prayers 2 and 3 as primary or main. Besides, the respondents' reliance on the second RDP case in relation to the argument of this court's jurisdiction, insisting that the applicants ought to have approached the High Court and to avoid this court deciding the matter as a court of first and last instance, does not, in the circumstances of this case, assist the respondents. The argument is devoid of merit because that case was in any event decided under the repealed Act, which did not have a provision similar to Section 172 of the Act. By using the term any challenge, a wide meaning is intended by the legislature. This in the context of a challenge to the outcome of a presidential election. Taking into account the primacy of the right to vote in the context of our constitutional democracy and its history, Section 172 is to be construed broadly and purposively. The challenge to the outcome of the presidential election is with reference to the minister's determination, which excluded a paper trail when use is made of EVMs. Properly considered, therefore, as a whole and plainly, or rather it plainly relates to the presidential election, given the direct relationship between the declaratory relief and the conduct of voting by AVMs. The election challenged by the applicants thus falls within the gamut of Section 172, and the jurisdiction objection is without merit and must fail. The respondents' challenge to this court's competence to adjudicate and grant the relief sought in prayers 2, 3, and 4 is in essence a repeat of the jurisdiction point, even though it's contended that Section 172 challenge is to be confined to irregularities occurring during and after the election. This narrow approach to Section 172 is inconsistent with its wide ambit by the use of the term any, and is also at odds with the purpose and context of Section 172, seen within the profound constitutional importance of a presidential election to the right to vote and the principle of democracy. This point likewise is without merit, and it must accordingly also fail. Now, turning briefly to agency, the respondents took issue with the agency with which the relief in prayers 2, 3, and 4 was sought. The applicants countered that if the applicants brought themselves within the ambit of Section 172, the matter is statutorily urgent, and that this point should likewise fail. The respondents correctly accepted that if the relief sought in those prayers is found to fall within Section 172, then the point concerning agency would fall away. Given the court's findings on jurisdiction, it must correctly follow that this point falls away. As to the argument regarding unreasonable delay, the respondents contend that the applicants unduly delayed in seeking the declaratory relief and the review of the minister's determination already made in 2014. The respondents point out that the challenge to the minister's determination under Section 209 was made some 5 years after the determination was made, and that this delay is fatal to the applicant's challenge. The respondents contend that the delay is unexplained and that the delay rule also applies to attack upon legislative action. The other cases relied upon by the respondents concerned delays in challenging administrative action. The present proceedings concern a challenge to the legislative act of putting legislation into operation on the grounds of it being in conflict with the constitutional principle of separation of powers. It is not necessary for present purposes to determine the ambit of the delay rule in relation to a challenge to a legislative act on constitutional grounds, and whether that should be distinct from a common law review of subordinate legislation. This court, in a matter of care, and the Chief of the Defence Force, held that in determining the question of undue delay in review proceedings, a court is to engage in two inquiries. The first is an objective and factual inquiry as to whether the delay was on the facts unreasonable. The second is whether the delay is to be condoned in the exercise of a court's discretion. If a court finds the delay to be unreasonable, it would then need to exercise its discretion in determining whether to grant condonation by applying the criterion of the interests of justice, as was stated by the South African Constitutional Court in a decision relied upon by the respondent, albeit with reference to other passengers, or other passages. And there it was stated that an additional consideration in overlooking an unreasonable delay lies in the nature of the impugned decision. In my view, this requires analyzing the impugned decision within the legal challenge made against it and considering the merits of that challenge. Also, this court in Sapa held that in the absence of a finding that the delay is so egregious so as to justify determining condonation without consideration of the merits, the criterion of the interest of justice would require a court to consider the merits. Applying these principles to the facts, therefore, the respondents do not contest that the first applicant, up to the 24th October 2019, operated on the basis that the assurance given by the ECN in 2015, and to an extent confirmed in February 2016, that it would seek to implement a paper trail for EVMs in time for the 2019 elections would be kept. Prior to that, the use of EVMs without a paper trail had been challenged in the High Court and dismissed in Maletsky on the eve of the 2014 elections. The first and some of the other applicants were not candidates in that election. The next relevant event is the assurance given by the Director of Elections in December 2015, which was to a large extent confirmed in February 2016 by the ECN's chairperson. As soon as the applicant became aware on the 24th October 2019 that there would not be a verifiable paper trail, he took up the issue in writing with the ECN the following day, and some 3 weeks after that proceeded to the Electoral Tribunal, the remedy created and prescribed by the Act. The first applicant was unsuccessful in that tribunal, and thereafter in the Electoral Court on an appeal, together with, if I understand it correctly, an urgent application in composite proceedings. The Electoral Court made its order on the day before, and reasons were given a few days after the election. That relief then became academic, and this application was launched within the tight time periods provided for in the Act and the rules promulgated under it. The steps thus taken by the first applicant, albeit in some respects imperfect, were taken without undue delay after, and I emphasize after, becoming aware of the absence of a paper trail on the 24th October 2019 for the purposes of a review. But there is a significant period of unexplained inaction on the part of the applicants prior to establishing the lack of paper trail on the 24th October 2019. As is pointed out in the context of the appropriate relief, both announcements in December 2015 and February 2016 are less settled, and both spoke of consultations with stakeholders before implementing a paper trail. That would need to occur timelessly prior to an election so that parties and candidates can properly prepare for its use. As the elections approached in 2019, stakeholders should have inquired from the ECN concerning the issue and not have left it to a mere month before the election to raise it, particularly in the absence of any announcement by the ECN or a further notice in the Gazette by the Minister. The prevailing legal position at the time was the Minister's determination which precluded a paper trail as upheld by the High Court in Maleski case. Whilst the applicants are entitled to rely on indications given by the ECN in December 2015 and February 2016, no further announcements were made on the issue, as foreshadowed in the statements relied upon by early 2019. And with the election approaching, it became incumbent upon the applicants to raise the issue well before at least mid-2019. Apart from the inadequate reliance upon the statements in December 2016 and February 2016, no explanation is forthcoming from the applicants as to why no inquiry was made on this issue until a mere month from election day. This portion of the delay is thus not adequately explained in our view. The failure to do so meant that the applicants delayed in raising the issue, even though they took steps after discovering the position on the 24th October 2019. Although the delay in the circumstances of this matter in raising the issue with the ECN is relevant in determining appropriate relief, it is not necessary to determine whether it was unreasonable for the purposes of the delay rule in the review proceedings, because the applicants should not be non-suited on this ground from raising this issue of profound constitutional importance and where the merits of the challenge are sound as is shown below. It is in the interest of justice, therefore, to grant condonation in this respect. It follows that the point taken by the respondents that the applicants should be non-suited on grounds of undue delay must also fail. Now we turn to the selective implementation of the Act. As counsel for the applicant submitted, the material facts concerning the passing of the Act, its assent and entry into force are not in dispute, even though the Minister did not place any material before court to explain the course adopted by his predecessor with regard to the selective implementation, namely whether that was made on advice and give the circumstances under which the decision was made. The question that arises for determination, therefore, is whether the Minister, in putting into force Section 97(1) and 2, while leaving Section 97(3) and 4 in limbo, acted in conflict with the Constitution. The applicants argue that this amounted to a breach of the principle of separation of powers entrenched in our Constitution, as we've seen before, whilst the respondents contend that the Minister was entitled to sever Section 97(3) and 4 from the rest of the subsections of Section 97 by virtue of Section 209 of the Act. Counsel for the respondents further argues that the granting of the declaratory relief by this court is a discretionary matter. This argument can be dealt with forthwith and very swiftly, I would contend. It has no merit because the respondents confuse the concepts of granting declaratory relief when, for example, the impugned conduct or action of an organ of state is inconsistent with the Constitution, as is the case in this matter with a court's power to grant constitutional remedies. In opposition to the application, the ECN states that it acted in accordance with the law as put in force by the Minister. The ECN also asserts that the Minister acted within his powers in putting the Act into operation in the way he did. The Attorney General merely states that he does not, or he did not agree with the declaratory relief sought in prayers 2, and that he opposed the relief sought in prayers 2 and 3. The Minister does not assert any basis for bringing the Act into force without subsections 3 and 4 of Section 97, but merely contends that his predecessor acted intra vires in doing so. He attached the ECN's letter of the 26th of February 2019 addressed to him, which stated that the ECN's position was that the introduction of EVPAT alongside EVMs, quote, will increase voters' trust and confidence and further enhance the credibility of our electoral system. The ECN also recorded in that submission to the Minister, quote, its considered view that the introduction of EVPAT is the right thing to do. The ECN also advised the Minister that a paper trail was not a legal requirement, and that it was not in a position to implement VVA-PAT in time for the 2019 elections. A verifiable paper trail as a check and balance of the use of EVMs is not merely to appear to provide comfort to voters that their votes had been cast, as is inexplicably suggested by the ECN chairperson and the ECN's expert, a certain Mr. Rao, as its sole purpose in the affidavits. This gainsays the ECN's chairperson's earlier statement prior to this application, correctly made in our view, that it provides a verifiable audit trail in the event of a dispute. The importance of a paper trail is also confirmed by comparative jurisprudence. The Supreme Court of India, for example, where the EVMs were sourced, held that, and I quote, "A paper trail is an indispensable requirement of free and fair elections." The Supreme Court of India in that matter also stressed that the purpose of VVA-PAT was both for the purpose of verification of a voter's choice and for manual counting of votes in case of a dispute. It would appear to us that this is precisely what Parliament contemplated in subsections 3 and 4 of Section 97. The German Constitutional Court has also concluded that electronic voting machines would only be compatible with the basic law of that country, subject to strict preconditions where, quote, "the constitutionally required possibility of a reliable correctness check is ensured, and where votes are recorded elsewhere in addition to the electronic storage. The principle of separation of powers is established in Article 1 of the Constitution and emphatically reaffirmed in the provisions vesting the legislative authority in Parliament. Article 44 states that the legislative power is vested in the National Assembly to pass laws with the assent of the President and subject to the power and functions of the National Council. In this instance, the President assented to the Act in its entirety. The legislature may delegate, of course, subordinate legislative powers, such as to regulate, to the executive and to put legislation into operation, but the legislature cannot devolve upon the executive any entitlement to select statutory sub-provisions to implement. It would be for the legislature to amend or repeal an enactment if minded to do so. In exercising the power entrusted to him under Section 209, the Minister is required to carry it out lawfully and consistently with the Constitution. In determining this, the question is whether the selective implementation was in conflict with the Constitution. Section 97 authorizes the use of EVMs in subsection 2 thereof. Subsection 3, however, makes it clear that the EVMs as authorized in subsection 2, the use thereof is subject to the simultaneous utilization of a verifiable paper trail for every vote cast by a voter, and any vote cast is verified by a count of the paper trail. Subsection 4 of Section 97 further provides that where the results of the EVMs and the paper trail do not accord, then the results of the paper trail will prevail. All these provisions, in fact, have been quoted earlier on, but they are being repeated for the purposes of emphasis. The use of the term "subject to" in subsection 3 of Section 97 means that the use of EVMs under subsection 2 is conditional upon complying with Section 97, 3 and 4. The legislative authorization of the use of EVMs in Section 97, 2 is thus subordinate to the conditions being met as set out in subsections 3 and 4. Section 97 is a composite and integrated provision. This means that those subsections were required to be put in operation alongside the power to make use of EVMs. It plainly exceeded the Minister's powers under Section 209 to selectively put into force the power to use EVMs without the conditions placed by the legislature for their use. It was not open to the Minister, in our view, to hold those provisions in abeyance, as the use of EVMs is dependent upon the safeguards placed in them. By doing so, the minister effectively deleted, for the time being at least, the safeguards enacted by Parliament, and thus usurped its role and breached the separation of powers provided for in the Constitution. In exercising his power under Section 209 to place the Act into operation, it was not open to the minister to subvert the intention of the legislature by implementing the use of EVMs without the safeguards expressly enacted by the legislature to which that use was made subject to, or rather made subject. By exceeding his powers and acting in conflict with the doctrine of separation of powers, the minister's determination is unconstitutional and invalid. As a consequence, it follows that the applicants are entitled to a declaratory order to that effect as set out in Prayer 2, and to have the minister's determination set aside also as sought in Prayer 3. Now we turn now to the consideration of an appropriate relief or appropriate remedy. The question arises as to whether this court should grant the further relief sought to set aside the election, having found that the minister's determination was unconstitutional and therefore invalid, and also having decided to grant the declaratory sought. It was also, of course, asked also to set aside the formal announcement or the declaration of the results on the 30th of November 2019, and to direct the conducting of another presidential election. As was stated in this court in CRAN, objective constitutionalism implies that a breach of the Constitution invalidates the implicated provisions from the moment they were enacted. In other words, ex tunc. And unless a contrary order is made, Section 23 2A of the Act and Item 6 should cease to have the force of law immediately. That is because of the default position that when a provision is declared unconstitutional, the declaration of invalidity operates retroactively. The inevitable consequence of which is that those who suffered its existence on the statute book should not be made to bear its consequences. Article 25 of the Constitution empowers a court in its discretion to allow Parliament, any subordinate legislative authority, or the executive to correct any defect in impugned legislation or action within a specified period, subject to conditions as may be specified, during which time the legislation or action may be deemed to be valid. Counsel for the applicants argued that the failure to give effect to subsection 3 and 4 of section 97 vitiates the 2019 presidential election. He referred to the Supreme Court of Kenya nullifying the 2017 presidential election in that country in the matter of Odinga on the basis that cross-verification in the form enacted by the Kenyan legislature did not occur. Counsel submitted that setting aside the election and directing a fresh election would amount to an effective remedy for the applicants. The respondents strenuously opposed the relief sought in prayers 5 and 6 of the notice of motion in the event of the declaratory order being granted. The ECN referred to the considerable cost of holding another election. Respondents' counsel referred to the discretion of this court in granting relief consequent upon a declaratory order, and submitted that this court should exercise its discretion against such far-reaching relief, and that any setting aside of the minister's determination should be prospective and not retrospective. Whilst cost and practicalities may be factors to consider, this court is, however, mindful of the right to vote entrenched in Article 17 of the Constitution. The essence of the democratic process lies in elections conducted with transparency and accountability, as emphasized by this court in the first RDP case. And the court may give effect to this principle whatever the cost to public finances in doing so. This court in the RDP first one case confirmed that a court would grant appropriate relief under the circumstances. The respondents' counsel further argued that the irregularities contended for by the applicants were not alleged to have materially affected the outcome, And in this respect, he invoked Section 115 of the Act, which provides, and I quote, "No election may be set aside by any competent court by reason of any mistake or non-compliance with this part, if it appears to the court that the election in question was conducted in accordance with the principles laid down therein, and that the mistake or non-compliance did not affect the result of the election." End of the quotation. Applicant's counsel countered that the outcome is not capable of being saved by a resort to Section 115. He submitted that the two requirements to be met in not setting aside an election are conjunctive and must both be met. Namely, firstly, if it appears to the court that the election was conducted in accordance with the principles laid down in the Act, and secondly, that the mistake or non-compliance in question did not materially affect the results. He argued that there was a clear non-compliance with the principles contained in Part 5, which includes Section 973 and 4, which meant that the first leg of Section 115 could not be satisfied and that effective relief should thus not be withheld. The principle contained in Section 115 is essentially that a court will be precluded from setting aside an election where a mistake or non-compliance is not material and where the election is conducted in accordance with the principles laid down in Part 5. It does not, however, necessarily follow that in all other circumstances that a court must set aside an election. A court certainly retains a discretion whether or not to do so. In the exercise of that discretion, a court would have regard to the circumstances of the case before it and grant appropriate relief as stated in RDP 2 case. We now turn to the factors that may be taken into account in the exercise of that discretion. In the founding affidavits, the applicants alleged irregularities concerning the operation of EVMs on election day, described by the applicants as, quote, multiple malfunctions by EVMs. It was, however, pointed out by the respondents that the allegations in the founding affidavit concerned 40 EVMs at 16 out of 4,213 polling stations, and that it was not stated how many alleged malfunctions concerned the presidential election. Furthermore, counsel for the respondents pointed out the allegations of irregularities and malfunctions were separately answered and refuted by the presiding officers at their respective polling stations, and further that one of the 16 polling stations contended for was non-existent. He also said that some of the complaints were not sufficiently specific by reference, for example, to a constituency, or by referring to a constituency and not to a specific polling station, which made it difficult for the ECN to verify the allegation. In a few instances, malfunctioning machines and beeping occurred, and these are explained in the answering affidavits. In one instance, there was a machine which stopped for 3 minutes and later went back on, with no one in the booth when it stopped. The other incidences of malfunctioning and irregularities are denied by the presiding officers at their respective polling stations. Upon the application of the Plascon-Evans rule in motion proceedings, the applicants have established very little in the way of irregularities or machine malfunctioning. The making of allegations of irregularities without properly establishing them is entirely unlike the position in the Kenyan case of Odinga, where it was said in that case that systematic illegalities and systematic irregularities were alleged against that country's commission, and where the court found that the illegalities and irregularities committed by the first respondent, meaning the election commission in that country, were of such a substantial nature that no court properly applying its mind to the evidence and the law can in good conscience declare that they do not matter and that the will of the people was expressed nonetheless. In this case, even where machines malfunctioned, the applicants did not apply to review electoral materials after initially indicating an intention to do so. Besides, the applicants do not contend that the machines had been tampered with. Counsel for the applicants' response to this observation was that there was nothing to review, seeing that there was no verifiable paper trail. But it would have been open, of course, to the applicants to apply to review electoral materials, which would include inspecting the machines in question and the request that they be opened up to check the votes cast and the results produced by those machines, and inspect for any evidence of tampering, and to check the security system of those EVMs. Significantly, this was clearly not done. The ECN's expert, Mr. Rao, who, although was not entirely independent in our view, by reason of being employed by the machine manufacturers in India, referred in some detail to security aspects of the machines and their reliability in the absence of a verifiable paper trail. This aspect of Mr. Rao's evidence has not been contradicted by the applicant's own expert, Mr. Shehama. There was little which remained to the allegations of irregularities after the answering affidavits were filed. The applicants have not shown that the absence of a verifiable paper trail has adversely affected their fundamental right to vote, particularly with reference to irregular use of the EVMs or their unreliability. The ECN's chairperson stated that whilst no election anywhere is perfect, the presidential election and that of the National Assembly reflected the will of the people and was transparent, free, and credible. Whilst the transparency and credibility of the elections were compromised by the lack of a verifiable paper trail, the question remains whether that adversely impacted on the electorate's fundamental right to vote. In our respectful view, this was not established on the applicant's evidence. What the first applicant says confirms that he exercised his right to vote, but under protest. Of course, what the latter statement seeks to suggest is not explained. It needs to be stressed that the ECN proceeded without a paper trail on the clear assumption that it was by law entitled to do so. The minister had in 2014 not put section 97.3 and 4 into operation, and when this was challenged, the High Court had in Maletsky case upheld the minister's determination and sanctioned the use of EVMs without a paper trail. The ECN had thus set out to act in accordance with the law as then determined and to comply with the principles of Part 5 as put into operation by the minister and found by the High Court to be lawful. This is entirely different to the conduct of the relevant commission in Kenya in the Odinga case, upon which the applicants relied, and also it's inconsistent with what was intended in RDP2, or rather it's not what was intended in the RDP2 case with reference to illegitimate means and methods. It would have been another matter entirely if the ECN had acted in defiance or in breach of his duty set out in the Act. On the contrary, his chairperson stated that the ECN was scrupulous in applying the law with reference to the Act, as then determined by the High Court, and it was satisfied that the EVMs were capable of producing a free and fair and credible election, as stated, and stated that the EVMs effectively did so. The previous elections in 2014 were also conducted in accordance with the minister's determination not to implement subsections 3 and 4 of section 97, and thus were conducted without the use of a verifiable paper trail, which has now been established to be in conflict with the Constitution. The current members of the National Assembly were elected in 2014 pursuant to those elections, and Parliament has passed legislation for the past 5 years, with the President also elected pursuant to those elections, assenting to that legislation, with wide-ranging implications, including those relating to expenditure and administrative action pursuant to that legislation. A further factor taken or to be taken into account is the failure of the applicants to raise the issue and effectively and tenuously challenge the lack of a paper trail after 2015 and 2016 and before the election. The ECN assurances concerning a paper trail are less categorical upon a close examination of the text of the actual press reports relied upon and attached to the founding papers. The statement by the erstwhile Director of Elections in a newspaper interview, as reported in December 2015, does in fact reflect that the ECN would use EVMs with VVAPAT as from 2017. The director, however, went on to state in the interview that the ECN would meet political parties and stakeholders as from 2016, quote, to discuss the modalities on how to implement the EVMs with VVPAT. The report concerning the remarks made by the ECN chairperson in February 2016 at the ECN's year opening shows that the remarks are even less equivocal, or less unequivocal, rather. The opening paragraph of the report states, and I quote, "The ECN will consider introducing a voter verifiable paper audit trail to accompany EVMs during the next elections. We will consider." The chairperson referred to the high demand and interest in the introduction of the VVPAT, and that a framework for acquisition and introduction of the VVPAT is to be adopted by the Commission, adding that all relevant stakeholders will be consulted during the process of developing this system to meet the country's needs. Those remarks were made in early 2016, as earlier mentioned. Whilst the director and the chairperson expressed an intention to provide for VVPAT, they both expressly stressed the involvement of stakeholders in the process of implementation. The chairperson's reported statement is, however, also tentative, stating that the implementation of VVPAT was under consideration. If the principle of a verifiable paper trail was of considerable importance to the stakeholders, including the applicants and their parties, it is inconceivable that there was no follow-up by them with the ECN to confirm its use well in advance of the election, especially after the absence of any announcement to that effect, which had been undertaken. Both reports expressly indicated that the consultations would precede the introduction of VVPAT. Stakeholders would need advance notice and consultations on the modalities of the operation of a paper trail, so as to prepare their monitors on their use. The lack of any follow-up on the part of any of the applicants on this crucial aspect is significant. As from 26 February 2019, the ECN would have informed them that there would be no VVPAT in time for the elections. If the ECN were to have failed to advise parties on this when seeking clarification on this issue following its communication to the minister and assessment, that would be another matter entirely, of course. The fact that the ECN failed to appraise political parties and stakeholders and the public, it must be emphasized, of the outcome of his submission to the minister on the 26th of February 2019 serves to compromise its transparency. And no reason is proffered by the ECN for this failure. And there was, however, the absence of any approach to the ECN on this score by any of the applicants before the 24th October 2019, when the first applicant states that he was disabused of the notion of the VPAT in the 2019 elections. Although the respondents did not raise this in the answering papers, it would certainly seem that this issue should have been raised with the ECN much more than a month before the election, given the assurances concerning consultations before the introduction of the VPAT and the absence of any further announcement by the ECN or the minister on the subject. The applicants sat back at their peril in waiting until the very eve of the election before taking up this issue, a mere month before the holding of the elections. Plainly, parties seeking to challenge the conduct of an election are under a duty to, quote, act timely, ensuring that potential violations can be remedied by the granting of an interdict or other forms of relief. And this quotation is quoted from a book by Ian Curry and Johan de Waal, entitled The Bill of Rights Handbook, 5th edition, published in 2005, and it's from page 458. This issue is raised as a factor in the exercise of this court's discretion as to further appropriate relief upon the granting of the declaratory relief. Whilst the applicants were non-suited in their request to set aside the determination upon the application of the delay rule in the review proceedings, the lack of expedition and the failure to raise the issue earlier are both factors to be taken into account in the exercise of the court's discretion to grant appropriate relief. Moreover, even after realizing the absence of VVPAT, it took the first applicant until the 13th of November 2019, more than 3 weeks before launching his application to the tribunal, which the tribunal heard on the 19th of November 2019, with its ruling and reasons provided on the 25th of November 2019. Whilst it's correct that the first application proceeded with the Whilst it's correct that the first applicant proceeded with the remedy contemplated by the Act to the correct forum and thereafter sought to appeal against the ruling of the Electoral Court on the next day, this was the day before Election Day. The first applicant, whilst pursuing the remedies provided for in the Act, could also have done so far more expeditiously after becoming aware of the lack of a paper trail, and not have waited more than 3 weeks before launching his application to the tribunal, given the far-reaching relief sought by him of interdicting the elections. It would also appear from the reasons given by the tribunal and the Electoral Court that the basis for challenging the absence of a verifiable paper trail was not raised as a breach of the constitutional principle of separation of powers by the minister in the manner now raised in these proceedings. We also take into account that the respondents did not place before us any evidence concerning the impact of any order of invalidity and its timing. It was open for them to do so, but of course they chose not to do so. These are all factors to be taken into account by this court in the exercise of its discretion concerning the appropriate remedy to be granted and the timing of its order of invalidity. They are also relevant in considering whether or not to grant consequential relief by declaring the election invalid and ordering a rerun of it. In the exercise of that discretion, we decline to set aside the election and order a rerun. This court in Kran delayed an order of invalidity where there had been a breach of separation of powers. As was stressed in Kran, the rule of law dictates that care should be exercised so that the effect of an order of invalidity is not rendered meaningless. That would not be the case where an order of invalidity is prospective, to ensure that Section 97 as a whole is adhered to or as a whole is not implemented until current EVMs are modified to produce a verifiable paper trail. A prospective order of invalidity vindicates the Constitution and ensures that future elections are held in accordance with what Parliament intended and in furtherance of the constitutional principle that elections are not only free and fair, but also transparent and credible. The order of invalidity of the minister's determination should be effective upon the end of the current term of office of those elected in 2014 on the 21st of March 2020, and after those elected in the November 2019 elections are sworn in. It should also not affect the validity of further by-elections held under the Act subsequent to the 2019 elections until the date of invalidity. In view of the timing of the order of invalidity, we have determined it follows that the relief sought in prayer 4 to set aside the ECN's adoption of voting by EVMs in the presidential election must be declined and would fall away in any event. As we have already stressed, the ECN proceeded on the basis of the validity of Section 209 determination as found by the High Court in the Maleski case. Turning to costs, we think that although the applicants have not succeeded in setting aside the presidential election They have vindicated their position concerning the invalidity of the minister's determination. They have thus been partially successful in these proceedings. In exercising our discretion with regard to costs, we also take into account that the minister in his determination failed in his duty to act in accordance with the fundamental constitutional principle of separation of powers, and that the applicants were vindicated in asserting this fundamental constitutional principle. We also take into account that much of the argument directed to this court concerned this particular issue. Taking these factors into account, we consider that the applicants should receive a measure of their costs set at 2/3 of their costs. Given the complexity and importance of the matter, the applicant's costs should include those consequent upon the engagement of 2 instructed counsel. Finally, I turn to the order. The following order is accordingly made. A, the determination by the minister that the provisions of Section 97 of the Act were brought into force with the exception of subsections 3 and 4 of that section on the 17th October 2014 by Government Notice number 208/2014 is in conflict with the Constitution and is invalid. B, the aforesaid determination is set aside. C, the aforesaid setting aside and order of invalidity will take effect on 21st March 2020, unless the determination by the minister under Section 209 is withdrawn by the minister before such date, in which event it will take effect upon the date of such withdrawal. D, the validity of the election of office bearers elected under Act 5 of 2014 before 20th March 2020, and action taken by them is not affected by this order of invalidity. And finally, E, the first to fourth respondents are jointly and severally ordered to pay 2/3 of the applicant's costs, including the costs of 1 instructing legal practitioner and 2 instructed legal practitioners, the one paying, the others to be absolved. That was the judgment of the court. Now then,
Lines, be ready when you are.
I'm ready.
It's just wait for it.
Jemima, it has been an hour and a half of notes.
Wow. What a tense morning.
Yes, you know, at some stage it felt like the ruling was definitely going to go completely in favor of the former independent presidential candidate Panduleni Itula. And although the court lashed out what I believe at the ECN and also at the former Minister of Urban and Rural Development about the selective implementation of the Electoral Act and that particular section of the Act, in the end, the court ordered that there will be no re-election. What do you make of what happened this morning?
Then I believe it was a fair judgment. Certainly set the trend for future elections. But yeah, this is what the court said, and this is what Namibia would have to accept.
Very well. We thank you for staying with us this morning. We'll bring you a lot more analysis during the course of the day. The evening review, of course, also awaits this evening at 6 o'clock, when Namibian Sun will help us understand the news of the day, and Republican and Algemene Zeitung will also do their part to make sure that you have the freshest angle on this story come tomorrow morning. But thank you very much, and thank you, Jemima.
Thank you very much, Denver.
Goodbye.